person. So he has made accommodations so that we can proceed with this while he appears virtually. So thank you, Mr. Borak. We are here for a hearing under section 241-19, appeal and hearing in the event that the chief of police refuses to renew or revokes or suspends a letter of authorization. The authorized town tower shall have the right to appeal such refusal, revocation, or suspension to the town board in accordance with the following provisions. And there are provisions in there. The hearing was requested after our chief of police failed to renew. And we are here at Mr. Borak and his client's request for this hearing for due process. Is there anything you'd like to add before I go forward, sir?
Yes. We're here because we sued the town to get the hearing under both 241 and Town Law Section 137. And Mr. Mustafa's license was not failed to renew. It was terminated in January of 2024. So we're here for provisions for the town law requires, the town law and the state law both require the town board to make the determination of any revocation, suspension, or failure to renew. And we've got a stipulated order requiring the hearing under the provisions of the Article 78 proceeding that we brought, which relate to both Section 137 of the New York State Town Law and Chapter 241 of the Town of Cheektowaga Code. We all set to proceed?
We are ready.
Okay. So I've given each of you council persons. And
do you want us to go first and present our proof, or do you want to make argument before we proceed?
No, we're going to make our presentation.
Without us putting out any proof? That's fine by me. Go, feel free. Thank you.
Yep. We're going to make our presentation. I've given each council person a binder which has 26 evidence tabs, and I've given the court reporter a copy of each of those exhibits in full. Your binders are printed in duplicate with the exception of the exhibit cover pages. So you'll look on each page, front and back. Each page is numbered beginning with page 1 through the remainder of the documents, I believe 196 of them. So when we refer to page numbers, it'll be easier than having to say exhibit 3, page 6. It'll be just page 65, whatever. First item I have in the exhibit folder is a copy of Chapter 241 of the Town of Cheektowaga Code. This is the section that deals with the issuance of licenses to town towers by the Town of Cheektowaga. It is the chapter under which Mr. Mustafa was given a license as a town tower by this town board back in July of 2022. We have an exhibit that shows the resolution. It's Exhibit 2. It was Resolution 2022. That exhibit starts at page 12. The exhibit itself is page 13. But let's go back to the town law itself because I want to highlight some information in here. Your town code itself has a very serious problem that impacts on my client, Mr. Mustafa, and Just Tow It. Section 241-6 of your town code, paragraph 16, states that permission for the Cheektowaga Police Department to conduct a fingerprint criminal history record investigation of the owners and drivers must be provided for any applicant, which Mr. Mustafa did. He provided that. Each owner and driver will sign a waiver. Such fingerprints will be forwarded to the Division of Criminal Justice Service along with the appropriate processing fee, which your chief of police did. But then it says authorization will not be granted to an owner or driver convicted of any felony. That provision in your code is absolutely unlawful in New York State. Absolutely, no question. We're going to get into the specifics of that when we get to your allegation as to why he shouldn't have his town tower's license because he employed a person who was convicted of a felony 25 years ago. All right. And we're going to show that that provision is absolutely unlawful. It's unlawful not only in New York state law, it's unlawful under federal law. The EEOC has a specific example, and we have that in our exhibits. We'll get to it, that shows you that you can't provide that. You can't have that provision. And this provision, by the way, this unlawful provision about not authorizing someone with a felony, that's also in your peddler's license law. You have a problem with that too. But as pertains to this particular issue, it's in the town tower licensing law, and it doesn't belong there. On page 10 of the documents, still within section 241 of the town code. Section 241.17, audits receipts. 241.17A, and excuse me, I have a bit of a sinus infection. 241.17A requires receipts to be provided weekly, on a weekly basis, invoices to be provided to the police department on a weekly basis, which my client did with the exception of about 6 weeks. There was an issue. We're going to get into that as to why he didn't do that. But it's important to understand that this is a requirement for all town towers, just not for Mr. Mustafa. It is in every town tower license. It's required. And the reason that becomes important, and we'll get into the details on it, but we asked you for copies of the receipts of a particular town tower for the last 3 years. We got back a certification they don't exist. I want you to think about that. Mr. Mustafa was a little bit late with some of his invoices going to the police department by about 6 weeks. But you have a tower out there who hasn't provided one invoice in 3 years. 3 years. And you want to take away his license? And then on top of that, of all the irony, when you took away his license, you gave his territory to that tower who's not providing any invoices, completely violating the law and the authorization. Section 241.18, revocation of letter of authorization. Now, this is under section 241. Prior to the annual expiration date, prior to means before. I'm not confused by that. I don't think any of you are either. It doesn't mean after the expiration date. His last tower license expired December 31 of 2023. Yet, the chief of police continued to operate with him under that license. In New York State, we have what's known as a course of conduct. And we'll get into that soon in the future too. When parties are in an arrangement that has an expiration date, but they continue to deal with each other in that arrangement, New York State law imposes a course of conduct relationship. Now, you can still revoke that course of conduct. You can still say, yes, Mr. Mustafa, we were engaged in a course of conduct with you as a town tower after January 1 of 2024, but now we want to revoke it. So then we're going to have the hearing, et cetera. That's fine. But you can't go back and backdate the non-renewal. You didn't not renew it. You didn't do that. You can't now go back and say, oh, but that's what we're doing now. That date's passed. December 31st, 2024, 2023 is gone. You can't go back and now say, well, we're going to make believe we didn't renew it back in December, when in fact, that's not what you did. And the law requires you to do so. And also, when we get into the town tower authorization license, you'll see it also requires that you do that. 2419, appeal and hearing. A refusal to renew or revoke or suspend a letter of authorization requires that it shall be determined by the board after a hearing. Again, after a hearing, not before. So the police chief can tell you, I think we should stop dealing with this person. But you have to make the decision, not the police chief. It's your decision, and you have to make it after a hearing. You don't get to suspend, revoke, or failure to renew before the hearing. That's clear under the town law. It's also clear under the New York State law. Exhibit 2, as I mentioned, is just the resolution for the record. Exhibit 3 is the towing letter, authorization letter, specifically for Just Tow It, Mr. Mustafa's company. And if you turn to page 17, paragraph 7 of the authorization letter, annually, before the expiration date of this letter of authorization, it says that the chief of police will notify whether or not it's going to be renewed. not after the expiration date, before the expiration date. That wasn't done. There was no notice sent to him before the expiration date. Page 18, this is going to become important later on as we go through this too. And this relates back to the problem with your law being illegal. The reason you cannot have a blanket no felons hired provision in your law is because under New York state law, you cannot discriminate under the executive law against someone solely because of a conviction. There are two conditions. If you can determine if they meet one of two conditions, that you can then say, okay, we're not going to hire them. But to reach those two conditions, you have to apply 8 factors, 8 specified factors. So you can't just simply say, oh, because you're a felon, no, you can't be here. You have to go through the process. Chief of police didn't go through that process. Your law doesn't go through that process. Your law just says, we're not giving you a license if you're a felon. But interesting, right in your letter of authorization, right in the very letter that you require him to comply with, paragraph 14, your firm will not discriminate. Your firm will comply with provisions of section 290 to 299 of the executive law and the civil rights law. Section 292.15 says you can't prohibit felons from being employed or refuse to give a license to a felon solely because of the felony. So you require him to follow that law. Then you go out to him and you say, we want you to violate the law. And if you don't violate the law, we're going to pull your license. You put him in a no-win situation. If he does what you want him to do, he's not only violating the law, he's violating the license. Absolutely improper. Exhibit 4, page 21. This is the termination letter. Issued on January 26, long after the expiration date in the existing letter. But it says in its own terms, not that, oh, by the way, we didn't mean to renew your license, so please stop responding to our calls. No, it says, we're going to revoke your license 2 weeks from today. We're going to continue to use you for 2 more weeks. Then we're going to revoke your license. And that's fine. You can say that, but you would have had to have that hearing both under 241 and section 137 of the state law before that date. You didn't. You simply didn't. That letter should have said, we're going to revoke your license. The town clerk will inform you about the date of the hearing. That's what your letter should have said. Exhibit 5, page 23. This is the New York State Town Law, section 137. After a public hearing thereon, at which the licensee shall have an opportunity to be heard, the town board may revoke any license issued under the authority of this article. And this article replaces all licenses issued by local governments and state governments, et cetera. And of course, it's subject to certiorari review. So no matter what decision you make tonight, if Mr. Mustafa thinks that it's an improper decision, we can also go to court and ask the court to review it, but that's not what at issue here. What at issue is whether or not you should revoke it in the first place. But again, you had to do it before. And by the way, the lawsuit includes a claim for incidental damages. Those incidental damages are all of the receipts he would have gotten from February 9th until you make your decision. So let's say you make a decision tonight that we're going to revoke Mr. Mustafa's license for whatever reasons you may decide are correct. And let's say the court says, you know what, they were right, they could do that. That's within, it wasn't so outrageous that we're going to overturn it. Fine. You still owe him from February 9th until you made that decision, the date you made that decision, because you should have been using him as a town tower during that period. And that claim is still pending before the court.